it's been a bit interesting, confusing at the same time. One would have expected that by this time, the defense would have taken shape. Everybody would have had an understanding of where Nnamdi Kanu is headed, or the kind of defense that his legal team will be putting up. But in preparation or in anticipation for today, we saw a shocker yesterday when he filed a motion that he would want the court to subpoena the people he categorized as vital and compellable witnesses. And these people include both former and serving governors, former attorney general, former chief of army, former chief of defense staff, former ministers and current serving ministers and all that. So when you look at that whole decision to call these witnesses, what does it signal to you? And as a legal practitioner, can you help us understand what Nnamdi Kanu, what he did there? Because a lot of people are completely confused as to the tricks or to the games that he played when he pulled that stunt.
Anyway, the first point of departure in this discourse is that I am here this evening to a great extent to discuss the legal issues surrounding the entire thing that is playing out. And in law, there is no place for sentiment or emotion. And to the best of my knowledge, I will do justice to the topic, devoid of how you may feel about it. Just like what happened during the last presidential election, vis-a-vis the manner in which the election petitions were conducted.
Right.
There is no place for sentiment in law, because whatever I say this evening, I know not all the listeners will agree with whatever I will say this evening. And again, this matter is sub judice. So while also commenting on it, we to a great extent try to make general remarks so that it wouldn't be seen as if I'm delving directly into the nitty-gritty of the case that is pending before the court of law. Now, having said that, as you rightly pointed out, this issue has become somewhat complex, in the sense that in the first instance, we should even take a look at the provisions of the laws under which Nnamdi Kanu is being tried. Why I made reference to the provisions of the laws is that, going by the latest preliminary objection which he filed, which, as you pointed out, the presiding judge noted that this issue has been addressed before. Nnamdi Kanu is contending that the law under which he was charged to court, that law has been repealed, being the Terrorism Act of 2011 as amended in 2013. Now, if you should also take a look at the punishment associated with the offense under which he was charged under the Terrorism Act of 2013. I wouldn't like to give any wrong or false information on air, but basically, I wouldn't know under the particular provision of the law upon which he was charged to court under the repealed Terrorism Prevention Act, because there are various facets of punishments associated with various calibers of offenses that one maybe, if one is found guilty under any of those offenses under the Repealed Act, then I know that the maximum punishment has to do with death. I think under section 1 of the amended law 2013, if anybody is found guilty of contravening that particular provision, the punishment is death. However, there are other lesser punishments for other degrees of offenses under that particular law. Now, why did I raise this issue? In as much as Nnamdi Kanu was tried, was arraigned in court under the now repealed Terrorism Act of 2013, the current Terrorism Prevention and Prohibition Act of 2022 made room for what we call saving clause. By saving clause, this current law stipulated that any person who was facing trial before this law came into force, before the old law was repealed. When I mean repeal, when a law is repealed, that law automatically ceases to have any effect. That law is buried. But it does not mean that if any legal rights accrued when that old law was in existence, that legal consequences will no longer be made to follow because a new law has been brought into force. And interestingly, this current law, the Terrorism Prevention and Prohibition Act of 2022, expressly recognized the fact that any existing case keeps being alive. Now, having said that, you should also take a look at the provisions of the Nigerian Constitution as far as the principle of fair hearing is concerned, with regard to criminal adjudication. This particular provision, I think section 36, subsection 4, it says that one cannot be found guilty of any offense which punishment is above that which was in vogue at the time that offense was committed. Just like what happened under the watch of the late Muhammad Buhari when he was the military head of state. Some Nigerians were made to face the death penalty for an offense which, at the time it was committed, the punishment for sin wasn't the penalty of the punishment of death. It wasn't a capital offense at the time it was committed. Now, I hope I'm not trying to digress. No, it's a complex issue. What am I trying to say? Having said that, irrespective of the law upon which Nnamdi Kanu is being prosecuted at the moment, the underlying factor is that if the punishment for the offense under which he's being charged presently, because he's being charged under the various laws, but I'm specifically making reference to the Terrorism Prevention and Prohibition Act. If the punishment is that of death or life imprisonment, then automatically he's under obligation to be represented by a lawyer. He cannot waive that right. He must be represented by a lawyer. He must. If the punishment for the particular criminal charge he's facing carries the punishment of death or life imprisonment, then a lawyer must represent him. That he must be represented by a lawyer now does not mean that he does not have the right to say, okay, I am done with so and so lawyer. In other words, what played out today, being that the former lawyers who are representing him informed the court that they are no longer offering legal representation. In the eyes of the law, Nnamdi Kanu is also empowered to also hire the services of other lawyers. However, if you take a look at the provisions of the Administration of Criminal Justice Act, which regulates the conduct of criminal proceedings in federal high courts, it's somewhat ambiguous. Let me explain. Ambiguous in the sense that a particular provision stipulates that if the punishment for an offense is a death or life imprisonment, then the defendant must be represented by a lawyer. On one line, we said that if it is death, the defendant must be represented by a lawyer. Then if it is death or life imprisonment, the defendant in case of death, be represented by a lawyer. However, in case of life imprisonment, that law wasn't too specific. In case of the punishment is that of life imprisonment, the law wasn't too specific. However, the concluding part of that same law turned around and in a nutshell and stipulated that once the punishment for any offense upon which a person is being prosecuted is either capital punishment, that is the punishment of death or life imprisonment, then the person must be represented by a lawyer. I also know that there is a clause in this particular law which provides that a judge can warn the defendant of the implication of not being represented by a lawyer. And if the defendant insists and proceeds in representing himself, it will not be a ground upon which that trial will be nullified for the defendant to not turn around and say that he wasn't represented by a lawyer of his choice. So it's somewhat ambiguous. But in a nutshell, whenever the punishment for an offense is that of a death or life imprisonment, to the best of my knowledge, the provision of the law is that the defendant must be represented by a lawyer. But if you now have a situation like what is playing out, you have the defendant and say that I don't want to be represented by a lawyer. To a great extent, what I will say is this: that defendant cannot turn around tomorrow, especially if he has been advised by a judge. He cannot turn around tomorrow and now say that I am not challenging the outcome of this trial on the ground that I wasn't represented by a lawyer. That had it been I was represented by a lawyer, that the result would have been different. Now, having said that, with due respect to our brother Nnamdi Kanu, honestly, I'm wondering how this defense will look like. Because even as a lawyer, once he gets to the stage of evidence, there are things you cannot do for yourself, even as a lawyer. If I'm handling my personal case now, if it's a case by way of originating summons, I can sit at the bar with the permission of the court and then conduct proceedings, because I will just adopt relevant processes. However, once I'm expected to enter the witness box, there are still things I cannot do. I cannot raise objection while in the witness box. If there are some documents I have to tender and the other side is objecting to those documents, I cannot, even I'm a witness or a lawyer. Of course, once you enter the witness box, you are no longer a lawyer in the eyes of the law. You are there as a witness, not as a lawyer. You cannot stay inside the witness box and raise objection. Now, there are some preliminary steps that a witness is expected to take before he now start giving his evidence, so to speak. How is he going to go about it? And the truth is this: in law, apart from these exceptions provided by the law, wherein a defendant must be represented by a lawyer, the law also encourages Nigerian citizens to represent themselves. So ordinarily it's a constitutional right, but no right is absolute. To every rule there's an exception. Even when you want to handle your case personally, maybe a civil matter, as a citizen. The court will not give you that free will to behave the way you like, or to conduct. You must conduct the proceedings must be conducted in line with the rules governing the business of that court. And honest, as I said, even as a lawyer, there are things you cannot do for yourself while you're in the witness box. And again, I've read some commentaries on social media platforms about people saying that Nnamdi Kanu wants to conduct his case personally, so that because there are certain things his lawyers are afraid of saying that he will not see by himself. With due respect, no. Because even if he's being represented by lawyers, those lawyers will not be the one to give evidence. He's the one that will give evidence, not those lawyers. Those lawyers will only guide him. Those lawyers will only raise objections or take necessary steps that lawyers are expected to take for the benefit of their clients. But his evidence is what to be relied on. And again, going by the proceedings of the Federal High Court, I know there's what we refer to as unsworn evidence. If he's not to enter the witness box, that is evidence will be regarded as an unsworn evidence. He can decide to give evidence while outside the witness box. But the weight to be given to that evidence to a great extent will not be strong, and it will affect his case adversely. But once he enters the witness box, then he has to be sworn on oath before he give his evidence. And meanwhile, everything you want to say has to be deposed to in an affidavit. Well, but let me say by way of oath, it has to be in writing. So whatever you want to say, this is not a case whereby maybe you enter the witness box and now start giving evidence and the court will record them. The court will only record evidence elicited during cross-examination, or evidence given during evidence in chief, maybe preliminary statements that be made by the witness, and maybe in the course of documents being tendered or any other vital exhibit being tendered, and objections that may be raised by the adverse party if need be. In other words, whatever Nnamdi Kanu may want to say will be in writing. So you will not enter the witness box and start. And again, anything you are doing, when you come to court, even during cross-examination, it is said that before now it is the conventional belief is that during cross-examination that the sky is the limit, that you can ask any question. No, these days you don't ask any question you have to ask must be tied to the issue at stake, the bone of contention. Now the government of the day frame criminal charges against you. You cannot, with due respect, embark on a voyage of discovery. You cannot start telling stories about Nigerian history. So you cannot start telling the stories about the history of Nigeria from inception. No, you have to address the bone of contention, the allegation brought against you. So whatever you want to say has to be deposed to on oath. You adopt that oath. So ordinarily, left for me, he should have sought and engaged the services of lawyers to represent him. But in the local parlance, it is said that Obogen with the plans. That's why we put it to Obogen with the plans. Now, also, I thought about the issue of saying that he wants to now present his case. Even when you represent yourself as a private citizen, there are things you are also not expected to say. You cannot, because you are representing yourself, now have a field day and say what the law does not allow you to say, or maybe embark on any contemptuous line of action. Maybe because as lawyers of a truth, we tend to be more careful. It's our business place. There are things that even if the wrong thing is being done, you follow due process in getting results.